Valerie McAllister and I'm a Senior Legal Executive in the firm of Dillon Solicitors, and today I'm going to talk to you about enduring powers of attorney and the importance of creating an enduring power of attorney. Well, a general power of attorney is a document effectively that's created by a person called a donor. So they give the power to an attorney effectively to look after their affairs, but in different circumstances to what's required for an enduring power of attorney. So an enduring power of attorney only comes into effect if a person loses mental capacity, whereas a general power of attorney becomes active if, for example, a person is abroad or if they're temporarily incapacitated due to illness but not mental incapacity, or if they're just unable to sign documents at a particular point in time. An enduring power of attorney is a very important document that's required to be created to allow for circumstances if, for example, you lose your mental capacity. So effectively, a donor, i.e. the person who creates the enduring power of attorney, effectively is allowing someone to look after their day-to-day care and control, their finances, and any care requirements in respect of rehabilitation, etc., in circumstances where they're unable to make those decisions due to mental incapacity. Well, your attorney can be a number of people. Effectively, if you are married, it should be a spouse. If you are not married, it can be a partner. If you are single or widowed and you have children, it can be your children. Or if there are none of those options available, it can be a remote or relative. So notice parties are two people whom are required to be notified under the enduring power of attorney document. The notice parties effectively are notified firstly about the creation of the enduring power of attorney by the donor, and then secondly they are also notified if or when the enduring power of attorney is required to be activated. So if the enduring power of attorney is required to be activated, the attorney effectively has to notify the donor firstly, then the notice parties, and then the Registrar of the Wards of Court office. Well, the attorneys owe a fiduciary duty effectively to the attorneys, so they take over the day-to-day care and control of their finances, so they're obliged to keep proper and adequate books of accounts. And if they're ever questioned, or if there was a fear that there may have been undue use of those funds, then effectively they're obliged to produce proper books of account, and they have to make decisions on or behalf of the donor for their benefit. The enduring power of attorney will only come into force effectively when the person, i.e. the donor who has created the instrument, has lost mental capacity. So effectively the attorney has to apply for the registration of the enduring power of attorney, but it does not restrict them from acting in the interim period between the loss of mental capacity and the actual registration of the EPOA. Well, as advised previously, the attorneys are acting in a fiduciary relationship with the donor, so they have to keep proper books of account. They cannot make gifts to any other person unless the EPOA provides for that. In those circumstances, the only people that they can make gifts to are people effectively who are known to or related to the attorney. So say, for example, a relative and or a charity.